Welcome to the Ohio Eviction Playbook.
Welcome back to the Ohio Eviction Playbook with Ed Kasputis. Ed is a longtime Ohio attorney, former state legislator, and the founder of Kasputis Law Firm. He approaches evictions through both a legal and business lens, helping landlords and investors avoid costly mistakes. I'm Chelsea, and today we're continuing our discussion on rent deposits, focusing on how those funds may be released along with related tenant remedies under Ohio law. Welcome back, Ed.
Thank you, Chelsea.
Starting with the release of rent deposits to the tenant, what are the different ways a tenant may obtain those funds, even though they cannot directly apply under RC 5321.09?
That's a good one. Do you say that all the time? Revised code 532109?
Yes.
Only lawyers do that when we are fighting with our wives or something. But anyway, number one is through negotiation. Many times you're just duking it out, and it's like, we're fighting over all this. How do we end this? Give them a little bit of money and all that. Number two is through litigation, and that's more drawn out. And you know what? I don't know. I don't know if it's cost effective even for the tenant, because you can fight and fight and fight, and it's like, my file is this thick, and in the end, the tenant is awarded $800 for $5,000 worth of work. And it can be vice versa for the attorney too, if the attorney or if the landlord has an attorney. Sometimes I've been in litigation where the tenant's going by themselves or out in left field. They're wasting everybody's time, but the court is respectful and they listen to stuff and all that, but it's like, that's not a legal concept. That's not a legal concept. That's not a legal concept. We find for the landlord. Oftentimes landlords, they just want some peace too. They don't want people leaving as their customer saying, I hate this guy, he was terrible to me and all that. But I mean, like, I once had a case where someone moved out and it looked like Smokey the Bear lived in their suite. Every wall was covered in like gray. And my client hired an HVAC expert. They said everything is fine. We figured it out. The tenant was burning cheap candles. And it was the candle wicks over a period of like 2-3 years that made it look like there had been a fire in the place. And the tenant just didn't believe it. We had litigation and everything. And in the end, the court ruled in the landlord's favor. But it was an expensive lesson for both the landlord and the tenant that just didn't want to acknowledge that if you burn candles every night, and they're kind of cheap, they can leave a residue on the wall. And, the landlord had to, try to clean it. In the end, they had to prime the walls, and then they had to repaint. But it was the priming and trying to clean it that they were charging the tenant for. But that's just one example of many where sometimes people don't believe anything, and it's like, send me a referee. Someone's got to make the call, because you can't convince them. And it's not that they're being untruthworthy. They just believe that they're right. And, sometimes that's true also for landlords, and they're not right. So here's another thing for rent deposits. The landlord always pays. The court assesses a poundage. And under the law in Ohio, the landlord always pays. So the landlord could be pure as snow. Let's say you're fighting over $8,000. The court will take 2% of the $8,000, even if the tenant was in the wrong and the landlord was in the right. That's just sometimes the government putting their thumb on the scale. They want to get paid, and they just say, no, we want to encourage tenants to use the rent deposit process, so we don't want to discourage them by charging them a fee. And that's the other thing. If you go to pay rent deposit, there is no fee to start rent deposit. When the landlord goes and he wants to file an eviction or he wants to file an action to get his money back, he's got to pay a filing fee. But for rent deposit, there is no fee to the tenant.
When a tenant is awarded a money judgment against a landlord, how can the court order the release of rent deposits to satisfy that judgment?
The court is holding X amount. So let's say the court's holding 9,000 and they make a judgment that the tenant is entitled to 2,000. They will direct the clerk of court, please issue a check in the amount of $2,000 to the tenant. Please issue a check for the remainder. Plus, we're charging the poundage fee of $9,000 to the landlord. So that's how you get it. Let's say you're fighting over 9,000, and for some reason the court awards a judgment of 12,000. Well, give what we have to the tenant, and tenant, you have a judgment now netted out of another $3,000. You can try to collect it. Good luck. And that's a misnomer that both tenants and landlords have. It's like they get a judgment. It's like, now what? Is the court going to make the people pay? No. The court's just watching like they're an NFL referee. No. 80% of all judgments rendered in municipal court are never collected. 80%. So I tell that to many of my clients when they want to sue somebody. My first question is, do they have money? I don't know, but I'm angry at them. Yeah, but do they have money? I don't know. Well, if you don't know, you're spitting in the wind. I used to own a 244-unit apartment community, Chelsea, for 16 years. If you saw the amount of work I did trying to collect money, you'd go, Ed, for every $1,000 you're collecting, you're doing $5,000 of legal work, and you're a lawyer. You're not billing yourself. What are you accomplishing, Ed? And I would often go home and tell my wife, I think Satan is making fun of me. He's wasting my life. He's wasting my life as I'm trying to chase someone down the street with the pitchfork. And it's like, hey, in our apartment community, we probably had $50,000 a year of bad debts. And it's like, Ed, take your brain and figure out how to make more than $50,000 somewhere else rather than chasing people down the street. So a lot of times I'm talking my landlords out of chasing people down the street. The first question I ask is, where do they work? And if they go, I'm not sure. Or they'll say, I think they switched jobs. Because here's another thing I learned, Chelsea, as I was trying to collect money. Bad employees are bad tenants. And I once got a judgment on a guy, and I found out he worked at Home Depot. I did discovery on him. Well, they just fired him after his 51st company policy violation. Bad tenants are bad employees. That's why they're bad tenants. So if you don't know where they work, strike one. If you don't know where they bank, that's strike two. Because you can do a bank garnishment in Ohio if you get a judgment, if you know where they bank. And so many times I'll have a landlord say, they always paid me in cash. Okay, well, that's a danger sign. If they had a bank account, that would be better. Let's talk about bad faith rent depositing. There is a provision in Ohio law that if someone does it and you can prove that they did it in bad faith, then you can get attorney's fees. Now, in law school, that's what they tell you. In practical life, I've been a lawyer for 38 years. I have yet to have a court determine that they had done it in bad faith. And I've had a couple instances where a landlord gives somebody a 3-day notice, they break some stuff, they call the city inspector. Next thing you know, my client is dragged into housing court, and it's like, I couldn't break this. It's inside the place. The tenant must have broke it. And the housing court says, all we know is it's broken. You should fix it. And I've never had that same housing court later on in litigation say it was in bad faith. So in theory, it exists, but I've never seen it yet. It's the unicorn of law that I have not seen yet, Chelsea.
Ooh, here's a juicy one. What happens when city inspectors find code violations?
When they find code violations, as a matter of law, you can't claim that they did anything in bad faith. So if I'm a tenant and I break a plumbing fixture and then I call the city, and then the city comes in and says, yeah, the fixture's broken, that's kind of a defense on trying to argue that the tenant broke it. And I've had many cases like that where they call the city. They don't call the landlord. They call the city. and use the power of government. And it's always happening when it's at the end of the relationship and the landlord is giving 3-day notices and trying to start the eviction process. And especially beware in the city of Cleveland, because they're very aggressive in going after housing code violations.
When a tenant terminates a rental agreement after satisfying rent deposit requirements, how does constructive eviction apply and what conditions must be met?
All right, let's talk about the biggie, constructive eviction. Constructive eviction is a defense. So let's say I'm your tenant, Chelsea, and you rent me a place and it's terrible. It's broken down and all that. Under Ohio law, I can start the rent deposit process or give you notice and say, I'm out of here. I'm out of here. I'm moving to Beverly Hills. I can't take it anymore. Now, from a practical standpoint, most tenants, when something like that happens, they don't have a plan B where they can go to. But one of the, so I'll have people call me and they'll tell me, Ed, I'm a tenant. This is terrible. I can't take it anymore. The first question I ask is, do you have a place to go to? And if they say, yeah, I go, okay, let's think this through. You're telling me your furnace hasn't been working for 35 days. Yeah. If you have the guts, you can claim constructive eviction and leave. What does that mean? That means that if the tenant or if the landlord sues you, you can use the defense of constructive eviction. But he's still going to sue me? He might. And if he does, you got to tell that to a judge and convince the judge that the conditions warranted that you were constructively evicted. I can't live here. I can't live here without a front door. I had a case where a landlord took a front door to repair it and didn't come back for 2 weeks. I can't live that way. That's dangerous. I can't live in a place where the furnace doesn't work. I can't live in a place where the air conditioning doesn't work and grandpa is on oxygen. I have been constructively evicted. And then there are times when I talk to tenants, and mind you, 95% of my practice is for landlords. But there's been times where someone will complain. I go, what do you do for a living? I'm on disability. And I tell them, you're kind of like Trump. What do you mean? You're not collectible. You can do whatever you want. You want to move out tomorrow? Move out. But that's the lay of the land for constructive eviction. You've got to have the guts that if you claim it, and you got to leave. You got to leave. You can't claim constructive eviction and still be there because the court will look at you and say, no, it had to be so bad that you had to leave. I had a foot of sewage in my basement and they weren't cleaning it up. It's a health hazard. I had to leave. And if I was representing a tenant, I would say call the government in and have them document that it was that bad as an additional evidence that you wisely had to leave because you were indeed constructively evicted.
How
You
does
should be a landlord, Chelsea, but go ahead.
You're painting a really pretty picture. It's looking fun.
You should be a landlord.
Finally, how does rate abatement operate as a defense in an eviction action, including how the court evaluates the landlord's rent claim and the tenant's counterclaim?
All right. So what happens for rent abatement? Let's say you're paying $1,000 a month, but let's say there's something wrong in your apartment, and you litigate, and you do a counterclaim for rent abatement, saying I've been paying $1,000 a month, but Your Honor, this place is only worth $800 a month. And I want you to make that determination. And I want you to get your calculator out, even though, Your Honor, you were an English major. And I want you to figure out that, hey, for 8 months I was paying $1,000. Then for a couple months I didn't pay any. And if it's only $800, do I have a credit? Do I owe anything? What I've learned, Chelsea, in litigation, rent abatement's not really worth it. You're litigating, and then let's say your rent's $1,000. The court will go, yeah, you're right. We're going to take $60 a month off your rent for the past 4 months. And you go, $60? $240? I spent $3,000, $4,000 to litigate this. Why did I even make this argument? So I've always been underwhelmed on how courts calculate rent abatement. you'll have tenants who will fantasize and say, "I should be living here for free instead of paying $1,000 a month." Why? Well, the windows leaked or this happened. It's like, well, when it rained, did you get wet? No. When it snowed, did you freeze to death? No. So what the landlord gave you had some value. Your dream of 100% rent abatement will never happen. So stop now. That's how I advise people when they come to me saying, I want rent abatement. They owe me. And it's like, no, they're not going to owe you. But if they do, it'll be pennies on the dollar.
Well, that's it for today's episode. Thank you so much, Ed. Thank you for joining us for the Ohio Eviction Playbook. If you want to learn more about Ed Kasputis and his work helping landlords and real estate investors navigate Ohio eviction issues, visit kasputislaw.com. Thanks for listening, and don't forget to like, leave a review, and subscribe to the show so you don't miss the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.